Hello and welcome back to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today we are exploring a deeply significant judgment from the Supreme Court of India, Kamalakant Mishra vs. Additional Collector and Others, SLP, Civil, number 42786-025, delivered by Bench of Honorable Vikram Nath Justice and Honorable Sandeep Mehta Justice on 12th September 2025. This is not just a routine property dispute, it addresses one of the most sensitive and important issues in our society today: the rights of senior citizens to their dignity, their home, and their protection under law. In this case, an 80-year-old father and his 78-year-old wife were forced to fight for their right to live in the very homes they purchased, simply because their children refused to let them stay. The Supreme Court's decision here reaffirms the protective purpose of a law meant to support and safeguard aging parents, and shows how the law can be interpreted not just technically, but humanely. Background, factual matrix. Let's begin with the factual background in detail. The appellant, Mr. Kamalakant Mishra, is approximately 80 years old, and his wife is about 78. They have 3 children. The eldest son, respondent number 3, is financially stable, runs a business, and is economically well off. Mr. Mishra purchased 2 separate properties in Mumbai. One room number 6 Nagina Yadav Chaul, Yadav Nagar, Mumbai. A single room in Raju Estate, Bengali Chaul, Sakinaka, Mumbai. Over time, Mr. Mishra and his wife moved to Uttar Pradesh, leaving these 2 Mumbai properties in the hands of their children. However, their eldest son took possession of both rooms and refused to allow his parents to live there. Feeling dispossessed and neglected, the couple filed an application on 12 July 2023 under Sections 22, 23, and 24 of the Maintenance and Welfare of Parents and Senior Citizens Act, 2007, the Act, praying for maintenance and eviction of the respondents from their properties. Proceedings in lower bodies. Now, let's go through how the case moved through different legal forums. 1. Maintenance Tribunal. On 5 June 2024, the tribunal accepted the application filed by Mr. Mishra and his wife. The tribunal ordered that the respondents must vacate both properties and hand over possession of the premises to the elderly couple. It also directed a monthly maintenance payment of 3,000 rupees in favor of the appellant and his wife. Appellate Authority, Tribunal Level. The eldest son, respondent number 3, was dissatisfied with the tribunal's decision, so he filed an appeal. On 11 September 2024, the Appellate Authority rejected his appeal, meaning the tribunal's decision to evict and pay maintenance was confirmed at that level. 3. Bombay High Court. Still aggrieved, the son approached the Bombay High Court via a writ petition number 14585-024. On 25 April 2025, the High Court allowed his petition. The High Court overturned both the eviction order and the maintenance order passed by the tribunal. Crucially, the High Court's reasoning was that the respondent himself qualified as a senior citizen under Section 2H of the Act because his date of birth, 4th July 1964, put him over 60. The High Court held that since he was also a senior citizen, the tribunal had no jurisdiction to evict him from the property of another senior citizen. Issues before the Supreme Court. When the matter reached the Supreme Court, several fundamental legal questions were framed. The court had to grapple with 1. Whether a maintenance tribunal under the Act has the power to order eviction of a child or relative from the property of a senior citizen, not just award maintenance. 2. Which date should be used to determine if someone qualifies as a senior citizen under the Act? Is it the date of application or some later date? 3. How should courts interpret this Act, strictly as a legal rulebook, or more liberally, purposively, keeping in mind its welfare objective? 4. Whether, even if eviction is allowed, the court should give time for compliance or enforce the eviction immediately, balancing the rights of the parents with fairness to the child. Supreme Court's reasoning and observations. Here is how the Supreme Court reasoned and what it observed in its judgment. The court emphasized that the Maintenance and Welfare of Parents and Senior Citizens Act 2007 is not a purely technical or procedural statute. Rather, it is welfare legislation whose underlying purpose is to protect older persons. Because of this welfare purpose, the court held that the provisions of the Act must be read liberally, so as to advance its humanitarian objective, not narrowly. On the question of age, the court made a pivotal finding: the relevant date for determining whether a person is a senior citizen under the Act is the date on which the application was filed before the tribunal, here, 12th July 2023. At that date, the son, respondent number 3, was 59 years old, so he did not fall within the definition of senior citizen under Section 2H. The court also slammed the son's behavior. Despite being financially stable, he denied his elderly parents the right to live in their own property. This, the court said, frustrated the very object of the Act, which is to protect the dignity and residence of senior citizens. Recognizing that an immediate eviction could be harsh, the court gave a reasonable balance. It granted the son 2 weeks, until 30th November 2025, to furnish a formal undertaking that he would vacate the premises by that date. Meanwhile, the tribunal's eviction order will not be enforced immediately, giving the son time to comply. However, the court was firm: if the son fails to give the undertaking within the stipulated time, the parents, appellants, can immediately move for execution of the eviction order, and any interim protection granted to him will be automatically withdrawn. Final decision, judgment. Summing up, this is what the Supreme Court ultimately decided. The High Court judgment, which had set aside the tribunal's orders, was overturned. The tribunal's eviction order, to vacate the properties, was restored, and the maintenance order, 3,000 rupee per month, was also reinstated. The son, respondent, must give an undertaking by 30th November 2025 that he will vacate the premises. If he does not give this undertaking in time, the eviction order can be executed immediately, and any interim protection he enjoys will cease. Legal importance and impact. This judgment carries deep legal and social significance. Let's examine the key implications. 1. Protecting senior citizens' rights. The verdict reaffirms that senior citizens' rights are not limited to financial maintenance. They also have the right to possession of their own property, especially when their children refuse to provide care or forcibly deny them access. The court's interpretation strengthens the protective ethos of the Act. It must safeguard the dignity, residence, and well-being of older persons. 2. Clarification on age criterion. By holding that the age must be determined on the date of application, the Supreme Court has closed a potential loophole. If age was calculated later, children could argue they are senior citizens if they turned 60 later, which could frustrate the protective purpose of the Act. This clarity will guide tribunals and courts nationwide, ensuring that age-based rights under the Act are applied fairly and consistently. 3. Interpretation of welfare legislation. The judgment highlights a broader principle in Indian jurisprudence: welfare statutes, especially those aimed at vulnerable groups like the elderly, must be construed generously, not harshly. By doing so, courts ensure these laws fulfill their spirit and purpose, and not just their letter. 4. Balancing enforcement and compassion. While the court upheld the right to eviction, it also gave the respondent a window to comply, thereby balancing strict justice with human compassion. This shows that the court is mindful. Enforcing the law is essential, but giving fair opportunity for compliance is equally important. Conclusion and call to action. To conclude, Kamalakant Mishra vs. Additional Collector is a landmark decision that strengthens the legal shield around elderly parents. It's a powerful reminder to all our legal system recognizes not just property, but dignity and care. What do you think? Will this judgment deter neglect of the elderly? Do you feel there should be even stricter mechanisms to protect senior citizens' property rights? If you found this breakdown useful, please like, share, subscribe, and hit the bell icon so that you don't miss more such legal insight videos. I promise to provide you with accurate, lawful, and well-researched information on a wide range of legal subjects on this channel. Your support is very important to me, therefore, I sincerely request you to stay connected with this channel. By joining the channel, You can also access exclusive legal insights and special membership benefits. Thank you so much for watching. Jai Hind and take care.